Right, so to start operations as a brewery or a brew pub, you need a brewer's notice. And that required for anyone that brews beer or produces beer for sale. That's the definition of a brewer. Anyone that produces beer tax exempt is not a brewer. Basically, those are home brewers. So home production for personal family use is permitted, and it's exempt from tax. And this is only on the federal level, provided that the producer is an adult. And regulations actually says 18 years old is an adult, but then defers to state law. So 21 is requirement for everywhere else. The producer's state also permits home production. There are some states, I believe, that still do not or are changing their laws that may have been changed. And the production doesn't exceed 100 gallons per calendar year per adult residing in the household, which is 200 gallons max, and that is 27 CFR 25.205. States may have different regulations about how much you can produce and where if you're a home brewer, but those are the federal rules, not more than 100 gallons per adult with 200 gallons max. Like the distilled spirits plants and the wineries, there are a bunch of basic requirements that are, they're all sort of similar. You need to have proper location. Again, it can't be in a house or attached to a house. The regulation defines it as a dwelling house. We've had questions as to whether you could then have a brewery in in a building where there's a condo on top, and the answer is maybe, if you can prove to TTB that there's adequate separation between the condos and the brewery. There's no way from anyone who lives in a condo above the brewery to exit their condo and get direct access to the brewery. They should have separate entrances and exits. So it's one thing that you would want to talk about with TTB or an attorney before you plan on this, because there are people who want to, say, build a brewery and then have either a house nearby or attached or what have you, or building them in urban spaces where you've got condos on top, a hotel on top. You need to prove adequate separation between two of them before TTB would do it. And we strongly recommend that everyone talk to an attorney, talk to TTB before signing that lease. What they also need is proof of ownership or a lease. So either you need a deed or a lease. And the lease needs to show that the operations, that the landlord is aware that you're going to be running a brewery at the location. If the lease doesn't say that, you can add it at the beginning, or you can always add an amendment or a rider to the lease, and the government will accept that. But it needs to show that the landlord is aware of what will be taking place on the premises. You also need to give description of the brewery location and the construction, and that the location is, again, the meets and bounds description, the tract of land that comprises the brewery premises. You can get that from the deed. Sometimes states and counties have online land records that you're able to get this, tax maps, things like that. That can be sort of difficult to dig up if you don't have it on hand. They also want to know about the construction of the brewery. What type of building is it in? They're not asking, you're using nails or screws, but basically, it's located in a 40 by 30 foot building that was zoned for commercial use, things like that. They also want to see a floor plan and a description of the brewery itself. The description is it's like a walkthrough. You enter the brewery through these doors, you turn left, walk along the wall for 20 feet, turn right, and go north about 50 feet. There's the fermenters and tanks, things like that. They want to know, again, about security, similar to for wineries and for distilleries. They ask you if you're going to have alarm systems or guards. You just give a short statement of what the security will be at the brewery You don't necessarily need to have the same kind of locks that distilleries have. It's not as much of an issue, but they do want a security statement. Also, the plant's impact on the environment. Again, these forms or the questions are identical for beer, wine, and spirits. They want to know who's providing your electricity, who's providing your natural gas, where will solid waste go, and for most people they just say it's going to go in local garbage collection, or we're going to recycle our spent grains and give them to local farmers for feed. That's fine. They ask some questions about water quality. Is there any runoff or anything that's going to go into navigable waters? They're pretty simple questions to answer after you get through it. And they also want a bond to cover the untaxed paid beer before it. The area where it's produced is, again, the bonded area. When it's removed from bond, then you pay the federal excise tax. So the bond covers the amount of beer that's untaxed paid. Just like with spirits, you can get a bond from an insurance company. There are specialized brokers who deal in alcohol beverage bonds. The form is very, very important, both again for breweries and distilled spirits. It has to be absolutely correct. For instance, if your company is John's Brewery, LLC, and on the form it says John's Brewery LLC with no comma, it'll probably get kicked back, and you'll have to correct it, and that can be kind of a pain. Recently, TTB started accepting bonds and power of attorney forms online instead of submitting them by paper. The paper way, when you had to submit 3 copies of each thing and you have to redo it, you have to send it back, overnight it. It would be kind of a mess. Now that it's electronic, it's still the paper form. They just want a good scanned copy where they can read all the signatures and they can read the seal of the surety, the seal of the company that's signing it. So those are the basics for Brewers Notice. There's another type of Brewers Notice, and that's an alternating proprietorships. It's very similar to what Lindsey talked about with the alternating proprietorship, same thing, and the custom crush arrangement. So it's basically an arrangement where 2 or more entities take turns using the physical brewery premises. It's generally called a host and tenant arrangement. So a proprietor of an existing brewery rents space and equipment to a tenant brewer. The tenant brewer may or may not have their own brewery somewhere else. Some breweries, small craft breweries now are, they're running out of space. They've got a whole bunch of orders coming in, but they don't have the space to add more fermenters, more tanks, more staff, things like that. So they might contract with a larger brewery, a contract brewery, to either produce the beer on their behalf, or in the alternating proprietor arrangement, where they would produce beer using the contract host brewery's space and equipment. They would keep all the records. They would label the beer using their own name, so it would be John's Brewery in Washington, D.C. instead of D.C. Brow in Washington, D.C. They get the label approval, they pay taxes at the appropriate rate upon removal, and they have to qualify as a brewery at that same location. So even if I have a brewery in California and I want to start an AP on the East Coast and in North Carolina, I would need to submit an entire brewer's notice for my location in North Carolina, even though it's not technically it's sort of a virtual brewery. I have to submit the entire brewer's notice. The host would have to submit an amended brewer's notice showing that they are going to be alternating with me. And there's there's no limit to the amount of APs that one producer can have, but it is, some people will use it for tax reasons, because if you are producing, if you produce less than 60,000 barrels of tax, you get a reduced tax rate as opposed to producing more. APs are different than contract brewing arrangements, and that's just kind of like the custom crush arrangement that Lindsey spoke about. Contract brewing arrangements, you can think, sort of how Sam Adams started out. They didn't have a brewery of their own. You contract with another brewery to brew the beer for you. You're just the brand owner. You own the trademark. You might pay for the ingredients, but you don't hold title to anything. And that's really the difference between a contract brewing arrangement and an alternating proprietorship. An alternating proprietorship, the tenant brewer will have title to everything throughout the entire process. They'll have title to the ingredients, the beer, untax-paid beer, the bottles, everything afterward. The contract brewer, they're paying the contract brewery to produce beer for them, to label it for them. They may use a trade name so they can have their name on the label as the producer, but they're not applying for label approval on themselves. They are just they're just paying the contract brewery to do this. They will most likely need a wholesale permit because they are if they take possession of or sell the alcohol themselves after the brewery pays the taxes and removes it from bond. So those are the difference between a contract brewing arrangement and an alternating proprietorship.